Hey, good afternoon, everyone. Thank you for joining us. My name is Janice Scarson. I'm a staff lawyer and an editor at the Centre for Public Legal Education of Alberta, CPLE for short. Welcome to our 1-hour webinar this afternoon, Sentencing, Navigating Criminal Court. I will introduce our panelists in just a few moments. I'm going to take care of some housekeeping things first. Jessica here at CPLE will be monitoring the chat during the presentation, and she may be making posts throughout that will be visible to the people watching. First, I'd like to make a land acknowledgement. The Centre for Public Legal Education respectfully acknowledges that we are located across Treaty 4, 6, 7, 8, and 10 territories, and respects the histories, languages, and cultures of First Nations, Métis, Inuit, and all First Peoples of Canada, whose presence continues to enrich our vibrant community. This presentation contains legal information, but is not to give legal advice. We give education to the public that is general in nature. I would also like to acknowledge our funders, the Alberta Law Foundation, the Department of Justice Canada, and the Alberta Real Estate Foundation for making webinars like this one possible. We will be recording the webinar for on-demand viewing on the CPLE YouTube channel. We ask that you save your questions until the end and use the Q&A function. Finally, you will be prompted at the end of this webinar to give a brief survey, and we at CPLE would really appreciate if you did that. We are a nonprofit organization. We serve all of Alberta. We are not government affiliated. We provide information and education through our various booklets, tip sheets, videos, webinars like this one, websites, and more. You can find us online at CPLE. Our goal is to make the law available and understandable to empower Albertans to use the law. This is our website. Here you can see all of the different categories of legal information that we offer. I encourage you to check it out. There's so much there to offer. Okay, now I am going to introduce our panelists, and I'm really excited about this. I know both of these gentlemen well through my career as a lawyer, and I'm very grateful that they've chosen to come here today and speak with you. I'm Janice Scarson. I'm a staff lawyer and editor of LawNow here at CPLE. My background is in criminal law, which is why I know these two gentlemen very well. Richard Morasti, he's a criminal defense lawyer. Richard is based in Edmonton, but like most criminal lawyers, especially here in Alberta, he can be found in courtrooms all across the province on any given day. His son, Jackson Morasti, is also a lawyer. He works at Pringle Law Criminal Defense, and Jackson is a former Gladue Report writer. I first got to know Jackson's work through Gladue reports that I often presented to the court. I was astounded by his brilliance and knew that he would be a good lawyer, and he's recently called to the bar, but shows the knowledge and experience of a much more seasoned lawyer. So because they both have expertise in the area of sentencing, I've asked them to be here today. I'd also like to note that they are both proud members of the Métis Nation of Alberta. So the first thing I'd like to discuss with Jackson and Richard is sentencing ranges. So people often say, why does it seem like two people can get very different sentences for committing the same crime? And there's a lot of factors that go into that and a lot of reasons why this happens. So I'm going to actually start with Richard. Richard, can you just briefly explain what a sentencing range means?
You'll have to unmute yourself there, Rick.
Oh, yeah, I can't hear you.
Sorry, Jackson calls me a boomer, and so do my other boys. I don't know how to. I'm surprised I actually made it on here because until minutes ago I was logged into Bonnyville for a decision with Judge Williams, and she knew full well that I had to be on WebEx or at this Zoom She was aware of that, but yet she kept adjourning. So I'm I may have to take off early, but I'm here.
Hey,
Um,
yeah, clients come first.
yes, yes. It's today is her last day. She announced to the court, and I'm not sitting anymore. And then she proceeds to be the same Kathleen I've known for 15 years. Anyway, but that's beside the point.
Very thorough.
Yes, range of sentencing. Um, the thing that I can say about ranges is it's a guideline that the court uses for certain offenses, for certain circumstances. There's a range of that's provided by case law for sentencing, and that's a range that the court looks at, but it's a guideline only because sentencing is very much an individualized process. They talk about offenders, same offender. Offenders should be treated in the same way. So the range of sentences would generally dictate that a particular accused would be sentenced along this range of sentence for this particular offense. However, you have to consider the individual circumstances of the accused, nature of the offense, and so it's merely a guideline that the court follows. It's not a hard and fast rule that they must be within that range.
Okay, so when we're looking at the factors that they would consider, so for example, in Alberta, the range for a drug trafficking offense might be 2 years to 7 years, and they would look at certain factors like the nature of the substance. Is it cocaine or is it fentanyl, which is more serious? What other factors an individual accused would play into that in terms of criminal record, that type of thing?
Are you asking me or Jackson or?
No, go ahead, Richard. You can...
Okay. The circumstances, the background, the personal antecedents of the client for sure are a big factor. I think you mentioned that Jackson wrote Gladue Report. So if a person who has what's known as Gladue factors, a history of trauma in the family, alcoholism, in foster care, FASD, those are normally what we consider Gladue factors. So that would dictate to the court a sentence that they could impose. And generally, within that range, but perhaps in a lower range of that sentence because of these factors, which can be mitigating.
And I'm going to let you chime in here, Jackson, on when your dad says mitigating and aggravating factors are things, terms we use as lawyers all the time in court. But for the average person, what does that mean, mitigating and aggravating factors?
Thank you. So firstly, the fundamental principle with sentencing is that the sentence should reflect the gravity of the offense or the harm caused or how bad the offense was, essentially, and the moral culpability or moral blameworthiness of the individual. So things like Gladue Report or the personal circumstances of that person, whether it be mental health concerns or reduced moral blameworthiness because of certain socioeconomic factors, those things all go towards the moral culpability of the offender, whereas the gravity of the offense doesn't really change depending on who the offender is for the most part. So, for example, assault might have as aggravating factors that the victim was vulnerable. They're an elderly person, maybe they were a child. Also aggravating could be if there was a weapon used, if there's injury caused, sorts of things that shape the confines of the sentence, right? Because assault can be anything from an unwanted push to bludgeoning someone with a baseball bat. So it's a wide range of offense conduct that would be aggravating depending on those little factors, right? So obviously pushing somebody who's bigger than you could technically be an assault, but that's not as bad as, assaulting an elderly woman with a weapon, right? So those are the things that allow a sentence that's commonly called assault to be broken up into multiple different things. And when you talk about moral culpability, things like childhood trauma, intergenerational substance abuse, the intention of the person, including their knowledge and awareness of the consequences. So, I guess what I'd say about that is that where somebody doesn't intend for a certain outcome to happen, but it does anyways, they're less morally blameworthy than somebody who knows that their actions will have a specific impact and then they do it nonetheless, right? Also, the age or moral development of the accused, as I already said, the mental health and FASD are all things that make them less morally blameworthy. So, to use your example of trafficking, somebody who traffics who's themselves a drug user, who maybe buys a quantity of fentanyl or something like that, and then sells it to their friends, which is technically trafficking, is less morally blameworthy than somebody who goes out and gets all those drugs and then sells them purely for a profit motive. Someone who's a user themselves is said to be less blameworthy because they have their own addiction that is driving them to get involved in drug trafficking, rather than someone who's just doing it to make money.
All right. And then that same person, or those same circumstances, if we use that, the criminal record would play in to the equation as well. If, for example, you had a prior trafficking conviction.
Right. So a related and recent criminal record is always aggravating. An older criminal record will become less aggravating, or less will be given less weight by the court because it happened a while ago. So the idea, I guess, is that somebody who has recently been convicted of an offense is then showing a disregard, or showing that they're not actually having their behavior corrected, which makes it more aggravating. Whereas somebody who has, say, a possession charge from 2014, there's been a gap there, or unless they're, at least a gap as it relates to the drug trafficking. So a record's aggravating because it shows that the person has already gotten in trouble and it didn't work last time. So now we have to do something greater than what was imposed last time.
Okay, thank you. Unless you have something to add, Richard, we can.
Oh, I just talking about the gap principle again. The gap principle takes into consideration that the gaps in time between offenses, and that's all I was going to add. Explain what viewers might be wondering what gap means, but it's actually a principle in law, in courts, a gap principle.
And also, just to answer kind of question one more succinctly, the reason why people get different penalties for the same offenses is because that offense might be broken down along a range of less serious to more serious, and also that individual is sentenced individually. So what is the same offense could get a dramatically different sentence depending on the moral culpability of that particular individual. So that's why you'll sometimes see people who commit an offense who get a very severe sentence, and then other people who commit a similar offense who are then found to be less morally blameworthy, and that's why they end up with a lesser sentence.
Okay, and also considering a lot of people might not know, but there's often a large gap between your conviction. I shouldn't use the word gap in a different context, but a time frame gap between your conviction and your sentencing date. So while you might get convicted on March 1st, you may not get sentenced until May 1st, for example. So in that time period, a person might go to rehabilitation. They might make amends for their crime, write letters of apology, whatever that may be. So my understanding is those things would also be considered by the judge.
Right. Those things are mitigating circumstances. So somebody who goes and gets treatment of their own accord without being ordered to by the court, that shows that they're addressing the root cause of what's bringing them before the court, and the court definitely takes that into consideration.
Okay, thank you. I'm moving to question 2, but it's somewhat part of question 1, and we've touched on a couple of these things. What information does the judge consider when sentencing someone? I think we've gone over that. And I would like to go into a little bit more detail about Gladue reports and pre-sentence reports and how they help a judge decide. So there's this maybe misconception among the public that only certain people are entitled to a report that the judge gets that talk about their personal circumstances. Most people think that the Gladue report is the only report available. There is an equivalent that is available to non-Indigenous people, the pre-sentence report. So both of those are available. I'd like a little bit more detail, and I'm going to ask you, Jackson, because you were a Gladue report writer, about Gladue reports, what they are, why we use them, and then Richard can maybe touch on pre-sentence reports, how they're the same and how they're different.
So I did write Gladue reports for about 5 years. I wrote roughly 120 of them. So I'm familiar from both sides, both writing the reports and now using the reports and ordering the reports in my own sentencing. And what I always say about Gladue reports is that the section that brought about Gladue reports in the criminal code, it's I don't get a little bit legalese here. It's 718.2 subsection E of the criminal code says that all available sanctions other than imprisonment that are reasonable in the circumstances and consistent with the harm done to the victims or the community should be considered for all offenders. And then it says, comma, with particular attention to the circumstances of Aboriginal accused. So the idea that jail is basically a last resort applies to everyone. That's not something that applies only to Indigenous people. It's just that this section also directs courts to take into consideration the circumstances of Indigenous offenders who might have a residential school history. There might be intergenerational substance abuse, intergenerational trauma, all these sorts of things that would reflect on their moral culpability. But again, that's applied to everyone. It's just that for Indigenous people, there's a connection between where they are now and their lot in life and Canada's colonial history because of the history of dispossession and dislocation and racism that has existed in this country and has led to people being disadvantaged. And largely, people who get convicted of crimes or people who get charged at all are generally from a lower socioeconomic class, generally disproportionately racialized, whether they be Indigenous or some other sort of racial minority. So the Gladue Report specifically is supposed to draw a connection between Canada's colonial history to the circumstances of the accused and their moral culpability. So somebody who witnessed substance abuse at a young age is less morally culpable than somebody who just sort of breaks bad out of nowhere later on in life.
Right, and I do remember, sorry to cut you off, a Gladue report you had written in the first sentence said something to the effect of this offender's use of alcohol started in utero, in the womb. So that offender who had been exposed to alcohol abuse from the time they were in the womb, was born with fetal alcohol syndrome, that would be something put into a Gladue report.
Yeah, fetal alcohol syndrome is a big bugbear of mine because it's a physiological change to someone's brain and their ability to react and respond to consequences. And there is specific case law about fetal alcohol syndrome and how that reduces someone's moral culpability. It also reduces the need to deter the public. And the idea behind that is that where there's deterrence, there's specific deterrence and general deterrence. Specific deterrence is we need to tell this person, cut that out, stop doing that, whatever it is that their offending behavior is. The sentence has to be enough to deter them. But general deterrence is other people who are seeing that or hearing about that, who are then saying, okay, well, I don't want to do this thing because look what happened to this other person. And I guess the idea for that is that a person who's got FASD, who has some other sort of mental disorder, is not the kind of person that we want to make an example of because somebody doesn't identify in the same way. It doesn't have the same effect on the broader community.
Yeah, so specific deterrence would be telling the person who already has 2 trafficking convictions, okay, you're not learning their lesson. You, in particular, you need to be taught a lesson, versus letting the whole general deterrence where the public knows, okay, if you get caught trafficking fentanyl, you're looking at, maybe a 5 to 7 year jail term.
Yeah, fentanyl trafficking is particularly serious because of how dangerous the substance is, though you can still get ranges or sentences outside of that range depending on the individual circumstances.
Right. And Richard, how about pre-sentence reports? How are those the same? How are they different? And who can get one?
Anyone can get one. Even the common practice, at least initially, about 10 years ago, was to get both reports, a PSR and a Gladue report for Gladue reports for Indigenous offenders. But courts often ordered also a pre-sentence report. I have stopped doing that, and I think most defense counsel have, because they're somewhat apples and oranges. A PSR or a pre-sentence report is like a risk assessment. The probation officer determines, interviews the client and collateral sources of information, and then files a report, and usually at the end they will almost always at the end they will make a recommendation. This person is not suitable for a community-based sentence like probation or something like that, because of the previous record. So it's a risk assessment based on the client's history. So almost every pre-sentence report that I have had for my Indigenous clients has recommended jail because of the previous history, the existence of a record, those sorts of things. So that's a pre-sentence report is available to anyone. The judge can order it for everyone. Normally, defense counsel requests it. For my Indigenous clients, I don't normally request one unless they specifically ask for both. So I don't know if I've answered that question, but really it is background information, familial information, history of say the same history that you would get in the Gladue Report for an Indigenous offender you get for a non-Indigenous offender, like if they've been in foster care. All of those antecedents are important in a PSR as they are for a Gladue Report. But that would be, I think, what differs is that it's an assessment whether or not they're suitable for a community-based sanction like probation.
Okay, so a pre-sentence report would give a recommendation, and a pre-sentence report would be written by a probation officer who might reach out to, you said, collateral contacts. I assume that's family, a boss,
yes,
things like that. And then the Gladue Report is written by a Gladue Report writer who is of Indigenous descent. And
not all Gladue Report writers are Indigenous.
For the most part.
Okay.
No,
So,
I know a Gladue Report writer, and she's about the whitest, blondest girl I know. So
okay, so you don't have to be Indigenous to do a Gladue.
No, you don't. It helps sometimes. People often feel more comfortable sharing with people who get it and who have a similar sort of background. But the white girl I know who writes Gladue Reports does a great job. So
okay,
she's able to build that rapport.
Yeah. Okay, so that's even a misconception that I had. Okay, now when we're talking about sentences, often we hear the term joint submission. Richard, what is a joint submission in sentencing?
A joint submission is both defense counsel and the Crown put a position to the judge for a recommended sentence. The judge doesn't necessarily follow it, but I would say 95, 98% of the time they do follow it. It's a joint recommendation for a sentence. I just sat in the Bonneville court and listened to a joint recommendation by the Crown and the defense counsel for a flight from police. She was a passenger in the vehicle, and the Crown and the defense counsel both recommended 90 days. The judge acknowledged that it was at the low end for a flight, but she was not the driver. She was merely a passenger. So the judge acceded, as they say, acceded to the joint submission, meaning she agreed with the joint submission. I think, as I said, 98% of the time, they will agree to a joint submission unless it's completely outside the range for that particular offense, for that particular offender. And then they have to justify reasons why they are not, why they are jumping this, what's called jumping the sentence. For example, giving defense and Crown agreed to say a 3-year sentence, and the judge jumps it to 6 years. Then they have to give reasons. There's case law in the Supreme Court of Canada, R versus Anthony Cook, I think that's it. What is it called, Jackson?
Yeah. Anthony Cook, yeah.
Yeah.
Okay.
Anyway,
so submissions for the prosecutor and the defense counsel before they came to court agree on the sentence.
Yes. And always in a sentencing, it's the ultimate decision maker is the judge. When we do these guilty pleas, for example, when it's a joint submission, we have to confirm with the court that Section 606, sub 1.1 of the Criminal Code has been complied with, and basically the client's pleading guilty on their own. You have to do a little checklist, pleading guilty on their own free will. They agree to the facts to make out the case, but also you have to tell them ultimately it's a decision of the judge, even if it's a joint submission. the ultimate decision maker is the judge. So you have to go through that drill. But long-winded explanation, it's really an agreement between the Crown. The general public will probably recall plea bargaining. That's part of the plea bargaining process.
Okay, and so the judge has less leeway to go outside of a joint submission than if it wasn't.
Yes.
Likewise, the judge has to give reasons if they decide to sway from the joint submission.
Yes.
As to why they don't agree with the defense and the prosecutor.
Yes, I think Jackson had a recent case on this as joint submission where it was jumped, or maybe it was me. I had
Wasn't
one
me.
I had one triple jumped in Lloydminster Crown, very senior Crown in the Northeast. The chief Crown and myself arrived at a 6-month sentence, and the judge came back with 18 months. So,
oh, wow, yeah, that's quite different.
Yeah.
Okay. Well, I think the premise or the logic behind a joint submission is that nobody knows the case better than the defense and the prosecution.
Yeah, absolutely. The shortcomings of the defense case and the Crown case, tribal issues, likelihood of conviction, those sorts of things play into the.
Yeah, and that's something actually I would like to just touch on for a minute, because when you read in the newspaper, you see these articles in the newspaper that, and the sentence just seems unfair. The public perceives it unfair, or somebody is acquitted of a crime that everyone's convinced that they committed. This idea of the likelihood of conviction, that sometimes in bail, it comes up in bail, people can't believe someone was released on bail on this serious crime, but the likelihood of conviction plays a huge part in that decision. How likely is it that the prosecution would get a conviction if this had gone to trial? And what you're saying, this also plays into sentencing. For instance, I assume this is when someone chooses to plead guilty, waives their right to a trial, chooses to plead guilty, and the prosecution concedes that they may not have gotten a conviction had they gone to trial. Am I on the right track here, Richard, with that?
Yes, and you often hear in submissions before a judge about why they'll say there were significant triable issues, and that's basically code for, hey, I may not have been able to get a conviction here. So maybe Jackson can elaborate on that, since he's so brilliant.
Yeah. All right, relax.
I'm just commenting on your introduction of him.
Yeah.
Brilliant.
Yeah.
I'm proud of him. But we like to tease each other.
Yeah, I know how proud
We
you
like
are.
to have fun here. Just to kind of iron out some of that, the joint submission serves utility in that case that dear old dad mentioned. Anthony Cook goes into why joint submissions are so important, and because it provides certainty to the accused that there's a very good chance that this is going to be the sentence that you're going to get if you agree to plea, which gives them some sort of peace of mind and gives them an idea of what they're looking at, rather than the risk and the uncertainty of getting convicted after trial. So when you plead guilty, you're basically saying, here's what you get if you plead guilty, which would be comparatively better than what you'd get after trial. And it also provides certainty that the Crown, who might have had, for all kinds of reasons, difficulty proving the case if it actually went to court, and then now, instead of having to fulfill their burden of proof beyond a reasonable doubt, now they have a guarantee that there's a conviction and a guarantee that that person is going to face some sort of sanction, whether it be jail or a conditional sentence or whatever it is, that there's going to be something, guarantee of something, rather than a chance at a greater sentence. And so if there's weaknesses in the Crown's case, they might be more inclined to resolve with the joint submission. And also where somebody pleads guilty, they're saving court resources, which is something the court takes seriously. So if you have a trial that might have been a 2-week trial with dozens of witnesses, bunch of police officers that have to pay to sit in the courtroom and wait all day for a trial, civilian witnesses who have to show up to court, especially complainants who are then spared the emotionally taxing burden of having to actually testify in court. The court takes seriously that person absolving the Crown of their responsibility because it shows remorse and it also saves time. So joint submission is very important because they provide that certainty to both sides.
That makes sense. So when we talked earlier about the mitigating factors, a guilty plea would be a mitigating factor that may lessen your sentence.
Yeah, it's always mitigating. A guilty plea, it's taken as being more mitigating where it's a guilty plea early. So I had someone in court the other day, first appearance, immediately pled guilty and took the Crown's offer. And so that's something because it's showing that at a very early stage, they're pleading guilty, saving resources that would be needed for further appearances and anything else that happens. They're charged, they plead guilty immediately. That's very mitigating. Whereas somebody who pleads guilty on the day of trial, when all the witnesses are ready, that's less mitigating, but still mitigating because it's a mission of responsibility and does save the actual trial time or the witnesses who would have had to testify. Sure, they don't get their day back necessarily, but they don't have to sit in court and be cross-examined, which is appreciated by the court.
And can be pretty emotional, like you said, especially for the complainant. So
yeah, and especially depending on the kind of crime.
Right. Okay, well, moving on to question 4, restorative justice. So we hear about restorative justice, especially the last few years, more and more. I'd like to know, what is restorative justice? And it's often spoken in the context of Indigenous sentencing, but it's so much more than that. It's not specifically set aside for Indigenous offenders, restorative justice. So I'd like to clarify that by talking about how programs like extrajudicial sanctions and alternative measures play into that. And perhaps it'd be helpful for those who don't know what extrajudicial sanctions and alternative measures are. Jackson, if you could just explain a little bit the difference between extrajudicial sanctions, what we call EJS, and alternative measure program, which we call AMP.
Right. So they're essentially the same thing, except for one of them is for youth offenders and one of them is for adults. Extrajudicial sanctions are for a youth who has been accused of some kind of crime. And unlike adults, youth are governed by the Youth Criminal Justice Act, which has special rules about every area of youth prosecutions, whether it be bail or sentencing or even police interviews. Youth have special rules about that. But extrajudicial sanctions are for youth who have been charged, and it's a way to resolve the charge outside of the court system. So that might look like something like an apology letter, restitution paid. There might be some sort of counseling or community service that gets done. And one of the things I did when I was on the Edmonton Native Youth Justice Committee was set up what we call sentencing circles, or sort of basically just an Indigenous sort of take on sentencing. And what you would do is have an elder, a youth, and their support person, maybe a family member, but also the victim and their support person. You get them all together in a room, and then you'd explain to the youth how their conduct affected the victim. And there's an acceptance of responsibility, and then you all sort of work together to create a sanction for that youth that acknowledges the harm done and provides some sort of reparation or the restorative aspect of restorative justice. And also results in the youth not actually ending up with a criminal record for that offense. So the one that I did was this youth had, with his friends, done some damage to a motorhome that was owned by this elderly woman. And we had the sentencing circle, and the elderly woman sat there with her husband, and the youth was there with his mom or something like that. And we all talked for a bit, and the youth really got to reckon with what it was like for this poor old woman who was getting ready to go camping and found out her RV had been vandalized. And so there's a greater recognition on the part of the youth for the harm done. The alternative measures is similar, but it's for adults. More often than not, it includes some sort of restitution or community service or something that's less onerous than what would be on a probation order. And we pretty much tell everyone to do AMP if they have the opportunity, because criminal law is all about risk, and AMP is a guarantee that your charges get withdrawn. If you get AMP offered, say for like a shoplifting or something like that. You pay restitution. Maybe you do a class on the dangers of shoplifting and the harm caused to society by it. And then at the end of the day, or at the next appearance, provided you do all those things, the charges get withdrawn. So you go from risk of conviction to guaranteed charges get withdrawn. So you always want to do AMP, pretty much in every situation.
Okay, and who makes the decision on what is to happen, whether it's a letter of apology or you donate to a charity or take a class? Who decides what is to be done?
That would be the Crown Prosecution Service, right, Rick?
Yeah, yes. It's funny that you should ask that because I had two clients that were involved in a shoplifting at Marshall's in North Edmonton. The female got AMP about 3-4 months ago, and I was also counsel for her boyfriend, who had a trial scheduled yesterday, and because of the weather. I mean, he had guaranteed to me that he was going to be there, but because of the weather, or some reason, it was he wasn't there. But I was able to talk to the Crown into putting it into 356 to give, which is a courtroom in Edmonton, to join up with a breach that he had, so that we can revisit the case. And one of the things I asked for was what's called parity of sentencing, that both offenders should get the same thing. But I also was quite aware that my client has a lengthy criminal record for minor petty offenses, including previous shoplifting. So she said, "I'll get back to you on that." And late in the day, she said to me, "He's not eligible." There's usually a Crown in charge of an office, or some more senior Crown who will either approve or not approve of AMP or XJS. But that's what happened yesterday.
Okay, and it would have been then the prior criminal record.
Yeah, that was the deciding factor for this client not getting AMP, and then the girlfriend got AMP. She had no record.
Right. So often alternative measures is offered the first time you get in trouble.
Yeah, sometimes the second time, and occasionally the third time, but not often. Once you get one or two kicks at the cat, and if you mess up, you don't get another chance. I wasn't real optimistic about my client getting out, but I thought I would give her a shot anyway.
Yeah, it's worth advocating for, that's for sure.
Yeah.
Yeah.
Yeah, the worst they can do is say no.
So extrajudicial sanctions, and that's a mouthful, I tell you, EJS and AMP are restorative justice in the sense that you're working to restore the harms done without the criminal implications. And then if you complete, it's withdrawn. What else can you tell me about restorative justice, Jackson, besides those two programs? How else is it being used in courts?
Well, restorative justice has sort of an indigenous connotation to it. And I think it's important to understand that whatever restorative principles are part of the criminal justice system, it's part of a larger system that is at its core a part of Canada and the federal government and the different provincial governments that manage prosecution. So there might be some elements of restorative justice that are baked into what is largely a Canadian system, but they are things that are increasingly finding purchase in different areas of criminal justice. And basically the idea is that it's to restore harm. It's not to get punishment necessarily or retribution. You want to get away from retribution and more towards a recognition on the part of the accused of the harm that they caused, and a greater appreciation for that, and also a greater focus on rehabilitation and reintegration. So the reason why you see it more commonly being offered to people without a criminal record, first-time offenders and stuff like that, is because those are the people that we see as most likely to basically get on the right track if given this opportunity to avoid a criminal record. And having a criminal record can make it harder to get work and can lead to secondary criminalization, which is a sociology term I won't get into. But basically, once you have a record, you're like, well, now I'm a criminal. So if you can stop someone from having a record, then that makes them that much more likely to go and get a job and be a productive member of society. So what's restorative about it is that it's designed to have the offender recognize the harm that they've done, take steps to address it, and also take steps to address what's going on in their life that led them down that road. So it's something that's more rehabilitative and less punitive, which the criminal justice system writ large is more punitive than rehabilitative.
Right.
But can I add something? It also involves the victim. The victim is a participant in, membership. It's like a voluntary engagement. Uh, you know, my friend. I mean, my 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 son. As Jackson said that it's forgot what he said, but it's a voluntary involvement of everyone. He talked about sentencing circles, and generally a sentencing circle involves the victim as well and the community. The sentencing circles that I've been involved in always have involved the families of the victim or the victim himself. I've been involved in probably 2 or 3. That's not that many for 20 years, but they're more common now, sentencing circles. But the one that I was involved in St. Paul was presided over by Judge Ladisher, and Terry Mazerolle was the crown, and it was my client's 7th or 8th impaired. Nobody was hurt except himself. He almost killed himself, but his circumstances were he had been sober for 15 years, and no record free for 15 years, and then all of a sudden, him and his partner broke up, and he fell off the wagon and crashed his vehicle near the intersection, just east of St. Paul, the intersection where Bonnyville, you're going to Kehewan, crashed his vehicle and almost killed himself. And initially, the Crown wanted 18 months of real jail, but after the sentencing circle, which was Judge Morrison also participated in that. He was a Crown at the time. The Crown and the defense agreed to a sentence of a CSO, conditional sentence order, where he served his sentence in jail. So they were, because the victims really was the state, because there was nobody hurt. So it wasn't there's an independent third party that was hurt. But Mr. Mazerolle, the Crown, was actually almost moved to tears hearing my client's story about how he grew up and changed his position.
So in that case, the sentencing circle was obviously really effective. And you mentioned, I'm going to clear up 2 little things that the public might not have understood in that. One, the friend, referring to Jackson as your friend. That's, for those who don't know, it's common practice for lawyers to refer to one another as my friend. So in court, if you hear defense counsel say, my friend, and point to the Crown, that's how we refer to each other. It doesn't mean that everybody's coffee buddies. It's just a term we use in the courtroom. The second term that might not be understood is a CSO. So when you referred to what happened after the sentencing circle, which is by no means a free pass, your client still received a CSO, which is what most people know as house arrest, correct? That would be the colloquial term for a CSO. A conditional sentence order is when you are sentenced to a term of imprisonment, but within the confines of your home. There's very strict rules about when you can come and go, if you can come and go from your home at all. And if you breach any of those terms, for example, you're not allowed to leave your house except to get groceries between 2 and 4 p.m. on a Tuesday. That might be what the judge decides. And you're caught getting groceries at 6 p.m. You could spend the rest of that time in jail.
Yeah,
correct?
called the collapse of the sentence. So they go back. Yeah.
Yeah, so the CSO has collapsed, and for whatever term it was, the offender now has to go spend that in jail. They've given up their option to do their jail time at home. Now, the third thing I wanted to touch on is the sentencing circle itself. So we have somebody curious that isn't familiar with that term. What is a sentencing circle?
So basically what it is it's a offshoot of the extrajudicial sanctions program. So when I did it, it was specific to youth. And what it is a way for the youth to take responsibility, to include the victim in the process, and to, like I said, have that meeting, that circle where they talk about what was done, how that affected the victim, what was going on in the youth's life and how they ended up doing that, and if there's any specific needs, like if they're a young person who's struggling with addiction, there might be a suggestion that they get into treatment. Usually, though, they would include some sort of apology letter, restitution, and if not restitution, something else basically to repair that harm. So it's an alternative to actually going to court. It's not something that happens in the courtroom. It happens in a separate location where either side, the affected party and the youth, have an opportunity to sort of share how they're affected by everything. And at the end of the day, they arrive at some sort of sanction or set of sanctions that the youth then has to comply with. And so long as they do everything that they're required to do, the charges get withdrawn. So it's an alternative. It's basically alternative measures program for youth, and the sentencing circle is one of those types of things that is commonly used with Indigenous youth because it's something that's more respected, especially if you have an elder there. There's a cultural significance that, in my experience, has made people more receptive to it and more likely to comply with whatever sanctions imposed.
Jana, the thing that strikes me, though, that a sentencing circle is you're already convicted or you have pled guilty. The charge is not withdrawn upon completion of a certain things that you have to do. For example, XJS, you might have to go full close at a woman's shelter or stock shelves at a food bank, and when you do that, the charge gets withdrawn under XJS or AMP. In a sentencing circle, it just by the mere fact that you're being sentenced, you've already pled guilty or you've already been found guilty.
Right.
Yeah, so I'll give you two recent examples where sentencing circles are really coming to the fore. There was a case out of Calgary not Calgary, Red Deer, on a manslaughter, where a man got a CSO, which is there was a sentencing circle. After the completion of the sentencing circle and hearing from everybody, Judge Marriott from Calgary, who was presiding over the case, imposed a conditional sentence order where the person 2 years less a day of a jail sentence, a CSO, but also followed by 3 years of probation, which is very low for a manslaughter. But everybody involved came to the conclusion, victim, the community, that this was a fit and appropriate sentence. And maybe about 4 or 5 years ago, there was a historic sexual assault in Cold Lake, where a man who was now in his 70s was found guilty after trial of a historic sexual assault of an 18-year-old girl. And the 18-year-old female was from his community, and she said to the court, "I don't want him to go to jail. I want him just to be accountable and acknowledge what he did to me." So they convened a sentencing circle. Judge Marta Burns from Calgary agreed to a sentence. The Chief Crown in St. Paul, who you're familiar with, asked for a real jail. You go to jail. But in all of the circumstances, this fellow had 30 years of sobriety, had been an alcoholic counselor, and he did something very wrong when he was 36 years of age. He never pled guilty and went to trial. But and the female victim gave evidence, and also said to the Crown, "I don't want my distant relative to go to jail." But the Crown still asked for jail. But after a sentencing circle, Judge Marta Burns gave a suspended sentence of 2 years, 3 years, I think. And a lot of things came into play. His rehabilitation, his age, his health. He was 74 years old, something like that. And he had, but for one impaired when he was 35 years old, he had no record.
Yeah, and when you refer to historic sexual assault, what you mean is that because there's no limitation period on being charged with a sexual assault, this crime had occurred over 30 years earlier.
About 40 years ago. 38 years ago.
Mm-hmm. So that's what we refer to when we say historic. There are certain crimes that you cannot be prosecuted for after a certain amount of time passes. But in Canada, sexual assault is not one of those crimes. You can be prosecuted for a sexual assault decades after it occurred.
Yeah. And I guess, Jenna, why I'm mentioning these two cases who are based on the very serious side, and you said earlier that the public might not understand why the person getting such a lenient sentence, if you will. But there's always some underlying issues, like I say, with my client, 30, 35, 40-year history of sobriety, working as an alcohol counselor, an elder in the community, a school bus driver. He lost his job because of this, because he was a school bus driver. Uh, those sorts of things enter into the play.
And most importantly, in that case, the consent of the victim. The victim was
Yes.
a party
Yes.
to that sentencing decision, and it was something that she had wanted to see. So that I think is the most important thing to point out. We do have a few questions.
Right before you do that, I just want to quickly correct something. So when I said sentencing circle in relation to XJS, that is different than a sentencing circle. They actually don't like to call them sentencing circles for exactly the reason my friend pointed out, is that the sentencing happens after a finding of conviction. So the sentencing circles are really an extrajudicial sanction circle, or some mouthful of words that's not as easy to explain. But when it's youth, in that context, then the charges get withdrawn. But an actual sentencing circle is post conviction or guilty plea.
From an Indigenous context, it's like a talking circle. Okay.
Couple quick questions. Somebody says, when it comes to plea deals, should you ever take one if you are not guilty? Oh my goodness.
You can't.
No, you will never. Yes, never take a plea deal, any kind of deal, if you're not guilty.
Yeah, at the beginning.
This is an interesting follow-up to that, though, which we had talked about section 606. I mean, that's a non-compliance with that section of the code. You cannot plead guilty if you're not. But they say, is taking a deal, in other words, is pleading guilty when you're not guilty, considered perjury?
It's not considered perjury. It's considered professional misconduct on the part of the lawyer.
Unethical. I mean, you often hear people, clients, they're in custody. I said, hey, I didn't do this, but I just want to get it over with. I'll plead guilty. And I always told them, hey, I'm an officer of the court. I'm not going to lie to the court and say, yes, he accepts the facts, because basically you're misleading the court. So I've often said, if you're going to plead guilty and you don't admit it, that you did this, then you're going to have to get a different lawyer, because there's ethical concerns, as like my friend.
And I almost inadvertently made that mistake once in my career, where a fellow wanted to plead guilty to an offense. Okay, fine, if you did it, but it wasn't until a really close review of his record that I realized it wasn't him at all that had committed that offense, that it was his father. So they had the exact same name, everything lined up, until I looked closer at the dates and I said, well, this is impossible. Who committed this offense? It's not you. And he said, well, that's also my dad's name. And I was trying to do him a favor. So he was going to tack this guilty plea onto his sentence to get rid of this warrant and his dad being in trouble at some point. So that's, as a lawyer, you have to be really careful when you're accepting a guilty plea, that you have gone over in great detail all of the facts and all of the birth dates. So that would have been a disaster had I let him follow through with that. That's just an anecdote. But
so one of the things, Jana, one of the things the court always asks, does the client agree with the facts, or they will ask the client directly, is that what happened? And then sometimes, and as you probably remember from your days in the court, they'll start hedging their bets. Oh, well, not exactly, but and then the judge will say, well, I'm not accepting this guilty plea. And then you got to go back and and maybe massage. So somewhere the truth is somewhere probably in there, but that I'm sure you remember that the judges refusing to accept guilty pleas because the client decides to hedge the bets so
and sometimes your client will agree to plead guilty, agree with the facts, but the judge also makes darn sure that all the ducks are in a row. There is a question here that I find interesting. They said, is it possible to go to trial and the person is proven innocent? Now, of course, people go to trial and they're not convicted. That happens all the time. But the word innocent, so innocent and not guilty are two very different things in legal terms. Jackson, can you explain the difference between being innocent and found not guilty at trial?
So everyone is presumed innocent whenever they're charged. It's a constitutional right that you have in the charter. And what is significant is that that burden's always on the Crown. It's on the Crown to prove your guilt beyond a reasonable doubt, which is a lot closer to certainty than it is to ambivalence or indifference. So the judge has to be basically, 80%, 85 to 90% sure that you're guilty in order to convict you. A finding of innocence is something that does happen, but it's exceedingly rare. I think I heard of it happening. I heard a story like once about it where they had said essentially that they find this individual innocent. He later ended up getting more charges and was convicted like 4 times later on similar charges. But basically, when you're found not guilty, that means the Crown hasn't met its burden to convict you beyond a reasonable doubt. So you're not found innocent, you're just acquitted because you're not guilty beyond a reasonable doubt. And I had a case where the judge said, this person probably did this, but probably is not the standard. You have to be a lot more convinced than just probably, because it's a very serious thing to get convicted with a criminal offense. So they don't do it lightly.
Yeah, sometimes I've had that. The judge looks at the video and says, looks like you, pretty sure it's you, but I can't say beyond a reasonable doubt. So on an identity issue, but when you see in the newspaper, a person was acquitted or found not guilty, you'll have people go, see, I knew it, he was innocent. Well, not necessarily. He just wasn't convicted.
Very true.
Question I had about stay of proceedings. So, Richard, what is a stay of proceeding and who can enter one?
The stay of proceeding, the Crown enters a stay of proceedings, meaning the case is stayed, and it's for a period of 1 year. And what they can do is bring it back within the year. It's not an acquittal. It's not a dismissal of the charges. It's a different procedure. The reasons probably because they don't have enough evidence or the reluctance of a witness. Those sorts of things sometimes play into the picture. The most high-profile stay of proceedings that I have ever not been involved myself personally, but was aware of was the stay proceedings on the Vader case, Travis Vader case. Remember the 2 senior citizens that disappeared near Edson somewhere on a way to a vacation in a motorhome, and Travis Vader was charged for first-degree murder for kidnapping them, and their bodies were never recovered. Well, that matter was set for trial, and then 2 or 3 weeks before the date of the trial, the Crown entered a stay of proceedings. But he wasn't scot-free, because what happened ultimately is about 11 months later, within that 12-month period, the Crown relayed the charges, and then he was ultimately brought to trial and convicted. But a stay of proceedings really is, I think, an abeyance of the charges. They're not necessarily withdrawn. They can always bring them back within the year. But having said that, a stay of proceedings is usually the end of the road. That they ultimately don't bring the charges back, particularly on matters that are not violent, less serious.
Yeah,
that's my take on. Yeah,
there's another thing though. It depends whether it's a judicial or a Crown ordered stay of proceedings. If it's a judicial stay of proceedings, then there's no option to restart it. If a judge, say, finds a charter breach and then orders a stay of proceedings based on that, then the Crown can't restart it after the judge has ordered it. So if the Crown stops it, they can say we're starting it back up again. But if the judge stops it, you're done.
Okay, thank you, Jackson, because that was actually the follow-up question that somebody had. Is there's 2 kinds, and which one can recommence and which one can't. So if the judge enters a stay of proceedings, that's it, it's over, frozen for life. If a Crown enters one, they may bring the charges back within a year, although I've never personally seen it happen. So
rarely happens.
Yeah. And the one thing that's unique about a stay of proceedings that frustrates some people is no reasons need to be given by the Crown when they enter a stay of proceedings. The judge might look confused or might be unhappy with it. A victim maybe, but the Crown is, my understanding, has no obligation to explain why they entered a stay of proceedings.
They typically do anyways. They don't have to, but they're talking to the complainant and will explain why that happened, and just to make sure that person has some kind of answer, but I don't think they technically have to.
Yeah, it definitely is appropriate to speak to the victim and explain as a prosecutor why you did that. But there's no legal obligation to tell the court why you're entering a stay of proceedings.
Right, correct.
Right. Okay. Okay. Well, I think we've sadly run out of time. I was enjoying our conversation, but it is 1 o'clock and people have things to do. I see Jackson's answering some of the questions that we had in our chat by typing the answers. So I appreciate that.
That's what I could say I'm a boomer. I didn't know what these Q&A, and I'm on my phone, so it's very small print. Okay.
Yeah. The one question somebody did ask, if you have several charges and might be responsible for 2 and not the third, should you take a deal? That's a question for your counsel. You should always speak to legal counsel in all circumstances. And it's free if you don't have a lawyer to get duty counsel. Never, ever, as we've discussed earlier, plead guilty to something that you didn't do. And duty counsel can help you. If you find yourself in court, you can't afford a lawyer, you're not eligible for legal aid, duty counsel will not help you run a trial, but they will give you some advice on that day and lead you in some ways as best as they can to the proper resolution, and can speak on your behalf to the prosecutor. All right. Okay, is there anything quickly either of you had to say before we sign off?
Nothing. I was going to ask the question about there was a question about the lesser of, you have 3 charges, and then, but I think Jackson probably answered that. Three separate charges, and you want to plead guilty to 2, you have to take the deal on it. Generally, what will happen is the Crown will withdraw a whole bunch of charges in return for 3 or 4. If 3 or 4 guilty pleas, say there's 10 charges on the information, they will withdraw a whole bunch and you plead to 3, something like that. So
right. Yeah. Okay. Well, thank you both very much for stopping and giving me an hour of your time today, and to the public, giving them your time. It is very appreciated, and I hope to see you both again.
Thank you for having me. It's a pleasure.
Yes.
And thanks everyone for your engagement and your questions. I'm trying to answer as many as I can before I leave. But if you want to hear more, give me a call. Pringle Law, Jackson Morasti.
Good job. Thank you.
My earplug just went south, so I got to plug them in. That's why
That's all right. We're done.
Okay. Thanks, Richard. Thanks, Jackson.
Okay. Thank you.
Bye-bye, everyone.